Okay, I realize that I am essentially the last person between you and the guest of honor, and so let me just introduce this last session. Um, as the program indicates, this session is on the role of a civil rights lawyer, and as Pam Carlin mentioned uh, this morning, we ought, in connection with talking about civil rights lawyers, we ought to take a moment to note the passing just 2 days ago of Jack Greenberg, who not only spent um, 35 years at the Inc. Fund, but Jack Greenberg was the last surviving lawyer who argued in any of the Brown against Board of Education cases. Um, and Jack was an inspiration to a lot of people, and so, as I said, I think we ought to take a moment just to note his passing. Um, the original plan for this session was to have two speakers, and we will sort of have two speakers still. One of those speakers was to have been Theodore M. Shaw. Ted Shaw is the Julius L. Chambers Professor and Director of the Center for Civil Rights at the University of North Carolina. He previously taught at Columbia Law School and at the University of Michigan, and of special relevance to this program, and particularly in light of the passing of Jack Greenberg. Ted Shaw spent more than 25 years at the Inc. Fund, including quite a few years as the director counsel. That is to say, the position that Jack Greenberg held, and before Jack Greenberg, the position that Thurgood Marshall held. Unfortunately, Professor Shaw contacted me on very late Tuesday to say that he has a serious health problem, and he clearly is not able to be with us. And he said specifically, not only is he unhappy to miss the program, he said, Fred Gray is one of my heroes, and I wanted to pay homage to him in person. I'm a small substitute to convey that message, but I thought I ought to. I'm sure that I speak for everyone here today in wishing Ted Shaw a speedy recovery. Now, the other speaker on this session is Professor Lynn Rubinowitz of Northwestern University's Pritzker School of Law. As I said, there will be two speakers. I will have a few things to say after Len, but at that point, I will be the last person between you and Fred Gray, so I won't go on too long. But I do want to take just a second to introduce Lynn Rubinowitz. Professor Rubinowitz has written 3 books and lots of articles, including a remarkable piece about the Montgomery Bus Boycott, and a massive piece that I think is going to turn into the 4th book on Martin Luther King and his lawyers. Beyond his scholarly achievements, I should note that Lynn Rubinowitz is an institution at Northwestern. He has won more than a dozen teaching awards during his career. And one other small indication, the Student Public Interest Law Organization at Northwestern's law school some years ago named its grants the Lynn Rubinowitz Fellowships. Now, on a personal note, I took several courses with Lynn while I was in law school. I've had some wonderful teachers at every level of education, from elementary school through college and graduate school and law school. And in front of all of these people, I want to say unequivocally, Lynn Rubinowitz is the best teacher I ever had. He is largely responsible for the fact that I am standing here today as a law professor. So at least partly your fault. Now, So it's really a special pleasure for me to introduce Lynn Rubinowitz, who's going to talk to us about courage and how that works both personally and professionally. Lynn?
Keeping in mind that I'm from Chicago, that means I have to send John a very large check for those remarks. But I do want to thank John, and in return tell you, especially students at Case Western, he's as good as it gets. It's a wonderful student to have. So, and I also owe him a great debt since then, because every article I write, in draft form I send on to John, and it comes back much better. The best I can do is put a little acknowledgement, but it's really more than that. And I want to add my thanks to the organizers, to Chad and the gang for putting this together. I personally think not only is Fred Gray a hero for me, but I think he is one of the most important lawyers in the history of this country. And this symposium seems to me helps to get the word out about that. I think that's an important thing to do, and therefore I'm very grateful for being invited. As John mentioned, I'm just finishing writing a very long, if not substantial, article about Martin Luther King's lawyers. It's about who those lawyers were, there's 60 or 70 of them, and how they came to represent him and his colleagues and the protesters, and how they were deployed. And one of the things that has struck me in the course of this article, which has a gestation period which makes an elephant's gestation period look like a weekend, is that the lawyers showed extraordinary courage. The challenges they faced, the risks they endured, the costs they paid to do that critical work. So to quote, where is retired Judge Daisy Collins from this morning if you weren't here? She said they are brave, brave, and brave. And those three words seem to me to capture it very well. I want to talk about two kinds of courage. John mentioned them, and I don't have good terminology for this, so I'm grateful for any suggestions about it. One professional and the other personal, and they obviously overlap. By professional, I mean navigating a racist legal system. Important, critical challenges with high stakes, and the whole system stacked against them. The police, the judges, the prosecutors, any adversary clients, the all-white juries who became all-white in all kinds of strategies and tactics to make sure that would happen. That's what I'm calling professional courage, navigating that system. Personal courage, I'm talking about the dangers and risks to them, their families, their children, in their participation. And the fact that they continued to do that work, that critical work, in the face of those kinds of dangers. So today I want to focus on the personal and celebrate that personal kind of courage. The white supremacists, Governor John Patterson of Alabama, who preceded Governor Wallace, and lots of others were trying their best to eliminate those lawyers, thinking that eliminating Fred Gray and other lawyers would deter, perhaps stop, and defeat the civil rights movement. So I want to discuss Fred Gray and several of his mentors, colleagues, and friends. First, I want to introduce those lawyers briefly. It's a diverse group by race, by gender, by location. And then I want to identify some of the categories or kinds of courage that they exhibited and give a few examples of each of those categories. So Fred Gray needs no introduction. As you know, he represented Rosa Parks and was Martin Luther King's first lawyer, first of many, and continued to be his lawyer in Alabama. Martin Luther King invited him to move to Georgia when he did, but he was committed to Alabama and he stayed. And I want to put in another pitch: read his book. Or as Judge Collins would say, read his book, read his book, read his book. Thurgood Marshall, not Southern, a Northern lawyer going south. Again, head of the NAACP Legal Defense Fund, or Inc. Fund, as John Ensign was referring to it. Once again, needs no more introduction. He started work, Fred Gray and Thurgood Marshall started working together during the Montgomery Bus Boycott. Lesser known, Arthur Shores. Arthur Shores is someone that Fred Gray referred to as the dean of Alabama African-American lawyers, not in Montgomery, but in Birmingham. He was a mentor to Fred Gray and many, many other lawyers. He's listed in Fred Gray's Bus Ride to Justice as one of 4 who affected his career. And by the way, I think there's been a mention of Judge Frank Johnson, and Judge Frank Johnson, federal district judge in Alabama, is also mentioned by Fred Gray as one of 4 who affected him. And one who was very courageous, was ostracized from his community, cross burnings on the lawn and so on, for taking a position in support of the Constitution. Third, who was mentioned very briefly, her photo was behind me, Constance Baker Motley. Constance Baker Motley was at the Legal Defense Fund for 2 decades. For most of that period, she was the only woman there. She was hired by Thurgood Marshall. She argued a dozen cases before the United States Supreme Court and won all but one of them. Later became the first black woman federal judge in the Southern District of New York. And finally, Clifford Durr, who's also been mentioned today, a white Montgomery lawyer and a mentor to Fred Gray. He said, I quote, "Served as my advisor on a daily basis during the formative years of my career." Was also listed as one of 4 who affected his career. So those are the lawyers, small sample of a much larger group of lawyers. I want to turn to the kinds of risks and some examples. And starting with physical dangers. And the most extreme examples of physical dangers that the lawyers face come from Arthur Shore's experience in Birmingham. There's a book written by his daughters and another writer just a few years ago, and the book title and the subtitle kind of capture it. The title is Gentle Giant of Dynamite Hill. Dynamite Hill is a black neighborhood called Dynamite Hill for a reason. And as the city, the larger city of Birmingham, was called Bombingham for that same kind of reason. The subtitle of the book is The Untold Story of Arthur Shore's and his family's fight for civil rights. That's a reminder that it wasn't just Arthur Shore's who faced those dangers, incredible dangers I'll talk about in a minute, but it was his family as well, his wife and his 2 daughters as well. So the story begins with bullets in the window. Their house had a big picture window, and bullets routinely came through that window, so much so that he had a repair person on retainer. When the bullets came through the windows, the repair person would show up to fix the windows. The police came once, ignored the thing. There were bullets. The police kicked the bullets down the street, said that's not of any interest to us. And so it became clear that there was no protection to be had from the police. Then the bombs started. August 20th, 1963, major damage to the house. Incredibly, no one was hurt. There was one room where the glass was blown out so hard that there were shards in the walls. And it was clear that if anyone had been in that room, they would have been killed by flying glass. They repaired the house, moved back in. 2 weeks later, another bombing. This time, Arthur Shore's wife suffered a concussion as she was knocked out of bed. The response to that, the way to deal with that, was armed guards who volunteered at night to protect the house. Constance Baker Motley and Thurgood Marshall often stayed at that house, and here is from Constance Baker Motley's autobiography, her reaction to that. They were in Birmingham for a hearing. While in Birmingham for this hearing, we stayed in Arthur Shore's spacious new home on the city's outlines. This house had been bombed on several occasions, but because we could not stay in a hotel or motel in Birmingham, we had to take up Shore's offer of his bomb-prone abode. It was a ranch-type house at the crest of a short hill, and there were no immediate neighbors. The garage had been built below the house, so it could not be seen until one reached the top of the hill. When Thurgood and I arrived, the garage door was wide open. Inside were 6 or 8 black men with shotguns and machine guns who had been guarding the house since the last bombing. It was the first time I had ever seen a real shotgun or machine gun. I had bought my son a toy shotgun for Christmas, so I knew what one looked like, but the real thing sent shivers up my spine. Although I tried very hard to do so, that night I could not sleep. Fortunately, when one is young, missing a night's sleep is easy. When we went to court the next day, the driver of our car and one other man in the front passenger seat carried guns. Then there was the bombing attempt. Sunday, March 21st, 1965. There were several green boxes spotted in black areas by church, other places in Birmingham. One of those boxes was spotted right outside the Shores' home. Just like a movie, the box was disabled 1 minute before it was set to go off at noon. They were all set to go off at noon. 1 minute before noon, it was disabled. The experts said there was so much dynamite in that box that if it had gone off, it would have destroyed most of the neighborhood. Fred Gray had bomb threats as well. His house was not bombed. His brothers and their friends guarded the house to protect it. Telephone threats, telephone death threats. Arthur Shores got them at his home, at his office. He kept changing his home phone number as a result. Fred Gray got threatening phone calls, hate letters, and also an attempted snapping. Attempted kidnapping of Arthur Shores' daughter. She was in school one day. A white man came to the classroom and said, "There's been an emergency. Mr. Shores wants his daughter to come home immediately." Thankfully, the teacher called Mr. Shores. No emergency. I did not send anybody. As she was on the phone, the white man was headed out to the parking lot, got in his car, and drove off. We will never know what might have happened if that kidnapping had been successful. Attempted lynching. In 1946 in Tennessee, there was an attempt to lynch Thurgood Marshall. He had gotten a number of black defendants acquitted. When the last acquittal happened, the police tried to take him to a lynch mob that was waiting down by the river where somebody had been recently lynched. Fortunately, there was an escape based on a decoy, so he was not in the car that they thought he was in, and he got out of town and never came back. And the person who was driving the decoy car got beaten up and ended up in the hospital. But when Constance Baker Motley, Thurgood Marshall went south, they knew that they were always in danger. They also knew and appreciated the fact that they were going to be leaving, and the lawyers in Alabama were staying and were going to be there for that. Clifford Durr, death threats for defending a black man. His car was parked outside church when there was a rally for Freedom Riders. Car was burned to a crisp, not recognizable. That's physical threats. There were legal threats as well. Some of those had something to do with the governor who preceded George Wallace, that's John Patterson, who was a lawyer and used the legal system in any way he could to eliminate not only the lawyers, but also Martin Luther King. That's another story. So Fred Gray was indicted for barratry. He was indicted because in the lawsuit challenging the bus segregation laws, the state statute and the local ordinance in Alabama, there were several women who were plaintiffs. One of them one day said, "I never knew anything about this lawsuit. I never agreed to be part of this lawsuit. I didn't sign on to be a plaintiff in this case." And that was the basis of the indictment. Well, she had been threatened, and so she lied to protect herself. Fortunately, Fred Gray, a good lawyer in all ways, had the documents that she had signed, and there was no way that could proceed. Beyond that, the case was dismissed because the case, the desegregation case, was in federal court. It was the state court trying to proceed on this indictment, and it had no jurisdiction. The other thing that was tied up in this is that if he had been convicted of barratry, he would also have been disbarred, and that was a major part of the story. So we're now still trying to get rid of Fred Gray. Fred Gray, as some of you know, was a boy preacher. He's a minister and a lawyer, and in Montgomery he was both a minister and a lawyer. For those of you who remember it, there was a military draft, and the draft provided a deferment for ministers. So he had a deferment. Well, his draft board decided one day because of the challenges he was posing, that he wasn't really a minister. They removed his ministerial exemption, and until the night before he was to be inducted, he was going to be inducted. The head of the Selective Service, as it was called, General Hershey, reversed that. My friend John Enton's view is that's the only good thing General Hershey ever done, but that's another story. Economics. Two kinds of issues, two kinds of challenges, economics. First, a risk, the loss of business, the great risk of economic reprisals, lawyers, family members. Clifford Durr was a very experienced, highly qualified lawyer, and his practice basically disappeared, except he cared about black people and he represented poor black people and he wasn't making any money. Ultimately, his practice got so decimated that he had to shut it down. In Fred Gray's family, brothers, sisters, relatives who had the last name Gray had a very hard time getting teaching jobs once people knew the relative. The other side of that economic issue is incentives. Incentives that were used to try to once again eliminate the lawyers from doing civil rights work. So Fred Gray was offered in his early days in practice, in his private practice, we will give you lots of clients, we will build your practice if you will agree not to do civil rights work. As someone has already said, and he has said many times, he was there to destroy everything segregated he could find. There was no way he was going to accept that. Arthur Shores was offered bribes, even by the Ku Klux Klan, if he would reject taking certain cases, and he rejected their offers. Economics. Social costs, lawyers and their families. The best example of this is Clifford Durr. He came from a prominent family that had been prominent for generations in Montgomery. He and his family were ostracized by most of the white community. His wife, Virginia Durr, wrote an autobiography. The title again tells some of the story. Outside the Magic Circle, the Durr family had been part of the Magic Circle for generations. They were no longer part of the Magic Circle once he got involved in the work that he was doing. The impact was heavy on his kids. That goes back to the family question, particularly hard on them. Teachers, classmates treated the Durr's kids as children of disloyal parents. It got to the point where with scholarship money and with help from friends, because they had no money of their own, they sent their daughters off to boarding school in the North. Arthur Shore's daughters couldn't have their friends over to the house because it was dangerous. The house could be bombed at any point, so they couldn't have their friends over to the house. They couldn't even spend time with their friends after school because Arthur Shores and his wife picked up their daughters at school in order to protect them against what might happen on the way back home. Social costs. Finally, psychological. As you can imagine, if you were a member of the Shores family after having 2 bombings and an attempted bombing, the ongoing fear that people had, the difficulty of sleeping and all the rest, even after that first bombing. And Constance Baker Motley's Sleepless Night is a reminder of that. Virginia Durr, the ostracized family, says, I look back on it now and I wonder that we stayed sane. So I want to conclude by fast forwarding several decades and reintroducing you to a lawyer that Natasha mentioned, another courageous Alabama civil rights lawyer. Brian Stevenson heads the Equal Justice Initiative in Montgomery, challenges racial injustice, and advocates for equal treatment in the criminal justice system. In his recent book, Just Mercy, that Natasha mentioned, by the way, after you finish Bus Ride to Justice, read Just Mercy. It's a wonderful book. He recounts his post-conviction representation of a black man who had been convicted and put on death row for killing a white woman. He had multiple alibi witnesses. He was at home at a church fundraiser with lots of people there who attested to the fact that that's where he was when the murder took place. The only evidence against him was a completely fabricated implausible story by someone who was induced, an informant who was induced to tell that story by the prosecutor. Stevenson and his colleagues, this is 1980s, 1990s, began to hear threats on their lives because angry white people thought that they were trying to help get a murderer out of death row. As a result of this representation, the organization received multiple bomb threats at the office, and Stevenson got death threats by telephone at home. It was tempting for Stevenson to treat these as bogus and to ignore the threats. But 2 years earlier, a Georgia civil rights lawyer was murdered when a bomb sent to his law office exploded. And other bombs were sent to civil rights offices in the South as well. So when a bomb threat came, Equal Justice Initiative staff called the police, evacuated the office, and waited outside while a police dog sniffed through the building and fortunately found no bomb. But for weeks afterwards, they took all their mail packages to the federal courthouse for x-ray screenings before opening them. In short, the need for courageous civil rights lawyers remains. This is not just a story that is safely in the distant past.
Thank you, Lynn. Let me pick up on some themes that Lynn has explored and also some themes that we have heard earlier in the day, but let me do this as briefly as possible. I want to offer a few comments on the role of civil rights lawyers in general, but also some about Fred Gray in particular. First, by focusing on the courage of Mr. Gray and Arthur Shores, the local lawyers in Alabama, as well as of Thurgood Marshall and Constance Baker Motley from New York, but were at risk when they traveled in connection with their work, this clearly shows something about the notion that lawyers hardly lead an isolated or insulated existence. Now, in honoring the lawyers, we should also remember the courage of their clients. After all, the clients were there in Montgomery, in Birmingham, and all of those other places, and they faced a lot of the same sorts of risks. Now, focusing on clients is important not simply because of the doctrinal rules about the law of standing, right? But also to illustrate the reality that litigation is not an end in itself, but a means to achieve broader goals in many instances. So let's take a moment to think about clients. People like Barbara Johns, who I think was mentioned at the beginning of the vice presidential debate. Barbara Johns, at the age of 16, organized a strike against segregated schools in Prince Edward County, Virginia, in the spring of 1951. That strike led to the filing of one of the cases that was decided with Brown against Board of Education. And to come back to this symposium and to pick up on some things that Wendy Parker talked about earlier, I want to say a few words about Anthony Lee. Personal words. I met Anthony Lee during the summer after my first year of college. He and I worked together on a civil rights project out west. And one day we got to talking about our high school experiences, mine in Greater Boston and his in Tuskegee. Anthony mentioned that he had attended 3 high schools to my one that was 2 blocks from my house. He explained that the schools were segregated, so he began high school in the black school, and then he said there was a lawsuit and then a court order, and so he got to go briefly to the white high school. But then, apparently, some diehard segregationists couldn't abide that, and so they bombed the school, And so he wound up at yet a third school. Now, he just said this like, that's just like the way people live, right? Well, what he didn't tell me, and what I didn't discover until some years later, Anthony Lee was not just a high school kid in Tuskegee. He was, in fact, the lead plaintiff in that case. And as Wendy made clear, Fred Gray was his lawyer. So that's one small point. Second, focusing on lawyers might imply that lawyers do only one thing. And this, I think, gets back, again, to some points that Wendy and others raised earlier. The idea that lawyers litigate on behalf of clients. But that raises a whole series of complicated issues that I just want to flag. For example, there's the question about whether the lawyer or the client controls the litigation. This is what Derek Bell famously called the interest convergence dilemma, and what, as Len mentioned, what diehard segregationists called barratry. Len mentioned the problems that Fred had in connection with the bus litigation. The Supreme Court eventually quashed a lot of those efforts to shut down civil rights lawyers in NAACP against Button, but that was down the road. Now, more important, the focus on the lawyer only as litigator buys into an oversimplified distinction between litigation and mobilization or direct action that lies at the root of some critiques of civil rights lawyering. We've heard some of that discussion today in a number of the questions that have arisen in the scholarly literature. This skepticism is perhaps most closely associated with Gerald Rosenberg's book, The Hollow Hope. And this is, I think, where Barbara Johns becomes critical to the discussion. On the day that the African American students at Robert Moton High School in Farmville, Virginia went on strike at Barbara Johns' behest, she found her way to a telephone and called Oliver Hill and Spotswood Robinson, who were NAACP cooperating attorneys in Richmond. And she asked them if they would take a case to help them get better schools. Now, Hill and Robinson had actually thought about litigating about educational inequalities, and they had essentially ruled out the possibility of litigating in Prince Edward County or anywhere in that part of Virginia because they thought that the area was so hostile that it would be dangerous, not just to them as lawyers, but to any prospective clients and to the African American community as a whole. Nevertheless, Hill and Robinson agreed that they would consider the request, but only if Barbara Johns and her cohorts could show that they had the support of their parents, and also if they would be willing to sue directly challenging segregation rather than simply to get a better black high school. There were two lengthy community meetings at which the issues were thrashed out. Hill and Robinson were persuaded that there was, in fact, sufficient local support, and that's why they filed the case of Davis against School Board of Prince Edward County. Now, the story of Prince Edward County is actually enormously complicated, and this also picks up, I think, on the story in Macon County, Alabama. For our purposes, I think it's sufficient to say that the events of 1951 show the interaction between litigation and direct action. There would not have been a lawsuit had the students not gone on strike. That lawsuit culminates in Brown against Board of Education. Okay. The story in Prince Edward County is actually much, much more complicated than that. Briefly, the local authorities closed the public schools in the face of a desegregation order, closed the schools for 5 years until another Supreme Court ruling ordered them reopened. Meanwhile, virtually all of the white students in the county went to a new private, whites-only school that was staffed by white teachers and administrators who previously worked in the white public schools. The Segregation Academy litigated for years to keep its tax-exempt status and only grudgingly admitted African American students, a small number, in order to keep their exemption. And then, in the face of that, they litigated all the way back to the US Supreme Court to challenge the validity of a whites-only restriction in a trust that had been set up for the Academy's benefit back in its early days. These are important and messy aspects of the story, but they shouldn't obscure the larger point about the relationship between litigation and direct action. We can see another illustration of the relationship between litigation and social mobilization in connection with the Montgomery Bus Boycott. And a lot of that David Garrow talked about this morning. Fred Gray talks about in great detail in Bus Ride to Justice. And I admit here that some of what I'm about to say I've cribbed from Lynn and his work on the boycott. But recall that the bus boycott was initially envisioned as a one-day protest to show support for Rosa Parks. And as David Garrow pointed out, the boycott initially did not seek desegregation of the buses, but rather more courteous treatment of African American passengers. It was really only when the all-white city government proved to be completely intransigent that the movement ultimately moved or sought desegregation. And to reinforce the attack on segregated seating, Fred filed a lawsuit, that ultimately was decided as Gale against Browder by the Supreme Court. The Supreme Court decision, by the way, came down in the middle of a hearing in state court on an effort by city authorities to shut down the boycott by going after the folks who provided the vehicles. Now, that ruling and even the Supreme Court's subsequent denial of rehearing did not, in fact, guarantee that the buses would be desegregated. After all, we are talking about a ruling in 1956, late 1956, a time when massive resistance was the norm in much of the South, especially in Alabama. Earlier that year, the University of Alabama had expelled its first African-American student, authoring Lucy, after litigating all the way to the Supreme Court to keep her out in the first place. And George Wallace was still an obscure county judge who had not run for statewide office, and it would be another 6 or 7 years before he proclaimed segregation today, segregation tomorrow, segregation forever, when he became governor of Alabama in 1963. So the point is that the white authorities might well have thought about defying the Supreme Court. But they had to reckon with the bus boycott. After all, the boycott had already gone on for nearly a year and ultimately would go on for 381 or 382 days. The authorities had to think about the possibility that they might not be able to shut down the boycott if they defy the Supreme Court. And So they had to factor that into their calculations. But even more important, the boycotters themselves had been looking to the courts for vindication. The boycott provided leverage, but at some point, if the authorities had been sufficiently hard-nosed, and there hadn't been a Supreme Court ruling, the buses might well have remained segregated. My point is that the Montgomery bus boycott illustrates the symbiotic relationship between litigation and direct action. Neither was sufficient, both were necessary. And Fred Gray himself illustrates that a lawyer can be more than a litigator. He played an important role in the proceedings that culminated in Frank Johnson's order that the Selma to Montgomery march would take place with protections from law enforcement. As you know, that march was pivotal in the adoption of the Voting Rights Act. And as David Garrow noted also, a few years later, Fred Gray was one of the first two African Americans elected to the Alabama House of Representatives since Reconstruction. So Fred Gray's career shows us that a great lawyer, and especially a great civil rights lawyer, but a great lawyer does more than win cases. A great lawyer like Fred Gray lives with the aftermath of the case and helps to make sure that a win in court is more than a symbolic victory. We have a long way to go, but Fred Gray has understood and helped to define what a great lawyer does. And so, for me, that's what makes this such a wonderful occasion. So that's what I have to say. Len and I have decided we're not going to take questions because we want to bring Fred up to say a few words. Now, Fred will have the floor for as long as he wants it. When we finish, there it will be a reception in the lower rotunda out where you signed in. And so let me add to the plugs for Bus Ride to Justice. There will be copies of Bus Ride to Justice for sale, and Fred will be glad to sign copies for you after that. So on that note, Fred, let me bring you up as the guest of honor. Now, I have been told that I am supposed to present to Fred. He got a big plaque at the alumni lunch. So here's another one for you. Okay, and now let me get out of the. Okay, we will fix this problem very quickly. Okay, it's all yours.
Thank you very much. If it had not been for Jonathan, I'll call him that because if I have a friend, he is truly a friend. Let's give him a hand for everything he's done to put this together. Let me first do a little housekeeping chores. You met my wife, she's here, a native Clevelander, and she's back home and eager for me to get through so she can go and spend a little time with her family before we leave on Sunday. We have my niece and nephew, Karen and Tom Jr., their father, and they grew up here in Cleveland. Their father practiced law here for years, and for the transportation system.
Yes, and then retired, and he had applied for a position, administrative judgeship, and after his retirement, the judgeship came through, and they said, well, the only place we have open is in Montgomery, Alabama. So he ended up ending his career about 10 years as an administrative law judge in Montgomery, the city where the state bar wouldn't let him pass the Alabama bar exam after I had filed so many suits that you've talked about here today. I probably have some other relatives. All my relatives, if you're here, just raise your hands. We're happy to have you. We're very glad that you're here. And Miss Daisy Collins back here, she's an institution herself. And it's interesting how I remembered she's been doing things, trying to get people to do things about the work that I've done. And I accidentally dialed her number a few days ago. And when we talked back, I said, well, let me tell you, I'm going to be in Cleveland in a few days. And she's here. So we're just happy to be here. It's good to be here. I spent 3 lovely years in Cleveland. And the interesting thing about the weather during that period of time, I brought some long johns with me, and I didn't need to use them. There was 3 mild winters, and I was very glad about all of that. Let me thank the deans of this law school, because but for them, this could not have taken place either. So let's thank them, and we appreciate them, and all the persons who have worked so hard in making this possible. And I want to thank each one of the participants, these professors. You've had them from all over the country. I don't know how Jonathan was able to get this assortment of professors to come, particularly to talk about cases for one lawyer. You know, we lawyers are pretty selfish, and we don't usually give accolades to somebody else. But I'm very appreciative to each one of them for what they have done and what they have said. And let me just give them a hand for everything they've done. And you know, this law school is not here for lawyers, it's here for students. And it is the law review, and Chad has done an excellent job, and all the other members of the law review. This is really your session. So for you to be willing to work it up and to have it in my honor, I want to thank you for what you've done. So let's thank them. And let's thank all the supporting staff, because you know, there are a lot of us who are out front, but behind us are those people in the office who we can call upon and ask to do all those things that we don't want to do. And we want to thank all of those persons who've done anything at all that has helped to make this possible. Having said that, and I prepared some notes that I was going to talk about, and I've sat here and listened to all of these things today. But there are a couple of things, and I mentioned this in the remarks I made at the luncheon when they gave me the Distinguished Alumni Award. But when I was a law student here, from 1951 to 1954, I never dreamed of being invited back to this law school to receive any kind of honor. I was too busy, one, trying to get accustomed to an integrated situation where I had an inferiority complex because I had never been in any type of educational setting other than a segregated one. But in addition to that, one of the reasons I selected this law school, because I wanted a good law school, and there are a lot of good small law schools, but I had to have a place where I could work. I didn't have any scholarships. My father died when I was 2, and I was the youngest of 5 children. My mother was a domestic worker. She did what she could and taught us as best she could, but she couldn't defray my expenses. So I had to be able to work. And because of that, I ended up finding that this was a good place to work, a good place where the schedule was of such that I would have time to work. So I never thought about being invited back. So for me to sit here today, and I said this for the benefit of you students, you can be what you want to be. And as you sit here now, I'm sure you're not thinking about any honors or anything else. You're just thinking about the next assignment and doing whatever else you have to do in order to make these things work. But if you do what needs to be done to get your work done, finish it, and then go and do what your heart tells you to do when you see problems to work on it, and you don't know anything about where you may end up going. So I didn't think about coming back. I was too busy doing what I had to do. But I sat here today. Now, for these law professors, and I'm not an academician, and I haven't been doing a whole lot of civil rights work lately, so I haven't been keeping up with all the current laws. And I don't, as a matter of course, go back and read opinions to find out which one of those judges may or may not have accepted or criticized one of the cases that I handled. But they were able to analyze it, and they deal with them every day. That's what they do, teach cases. But to you, they're cases. But to those individual parties to that lawsuit, to those plaintiffs, and to those defendants, it wasn't just a case. In some instances, it's a life or death situation. So I never thought, and people always ask me about, well, what did you think about this, or what did you think about that, or what was the most important case you've handled? I think what all lawyers have to realize is that any time a client comes into your office with a case, as far as that client is concerned, they don't care anything about any of your other cases. They don't care whether you ended up with a $5 million verdict, or whether you were on the defense side and got a defendant's verdict. What they want is whatever their problem is that they bring to you, they want you to solve, help them solve that problem. So each one of these cases that you've heard about, from my first one, which was Claudette Carvin, and Claudette, if she hadn't done what she did when she did it, none of these other things that happened in Montgomery probably would not have happened, because she gave moral courage to Joanne Robinson, to Fred Gray, to Rosa Parks, to E.D. Nixon, to Rufus Lewis, to the 40,000 people. They were able to say, if this 14-year-old girl could do what she did without any preparation or not knowing how she was going to get out of jail, but she knew she was going to go once she decided to stay. So what I'm saying to you is that these were real cases. I wasn't thinking about setting precedent. I wasn't thinking about starting a civil rights movement. Now, I admit, and there's no question about the fact that I wanted to do the legal work And I wanted to destroy segregation, and that's why I was there. But as each one of these cases came up, from Claudette's, and there were some people who were critical about her. But whatever you're going to do, there's going to always be somebody out there. But what you do is try your best to analyze your cases, do the best you can with them, and have enough sense. Like me, once I was retained to do the work, I realized how inadequate I was to do it, and that I needed some help. And I got on the phone and called Thurgood Marshall right after I was retained. I went to Mr. Nixon and said, you know how I can get hold of Thurgood Marshall? And he told me. I called him, told him the whole situation. He had been reading about it. I said, I want to come to New York. I think I'm going to ultimately have to file a lawsuit. And I need your help. He told me to come. I met him. And Robert Carter was his chief assistant at that time, who later became a federal district judge in Manhattan, and established a working relationship with the NAACP and then later the NAACP Legal Defense Fund that has lasted from that midday in December of 1955 until today's date. But I had enough sense to know that I needed some help. So each one of these cases, and I was very interested in listening when, and several persons have talked about Smith versus Parrish. Most folks don't know anything about it. That's the little case down in Barber County where blacks were trying to serve on the Democratic Executive Committee, and I'm going to tell you why they were trying to do that. And what they had, and this is right after, this is the first real election after the passage of the Voting Rights Act. So now we have a lot of blacks who are on the roll. And these blacks in Barber County lived in a little section where it was a majority black area. And what they had in the past was election on beats, based on beats. And based on their beats, we would have had about 3 or 4 beats that would have been black, and the rest of them would have been white. And they changed it and made it basically so you had to run at large. But there was another part to it. Do you know Fred Gray was running for the Alabama legislature during that same year? And Thomas Reed, another African American, was running for the legislature during that same year from Barber, Bullock, and Macon County. We needed those persons because they could help to get other votes out so that they would not only get themselves elected, but would also help to get the first blacks elected since Reconstruction. And you had another situation in another case up that nobody said anything about, and that's Parrish. No, that's Trussell. I'll think of the first name in just a moment. But again, once we began to get the votes, and you had black county commissioners running for office in Bullock County, Alabama, and that was also one of the counties that we needed. What happened in that instance is the legislature passed a law again extending the term of office of the white commissioners in there so that blacks, even if you get registered, it don't make any difference because the term is not up. And the court knocked down that. So we had all kinds of problems. We saw one problem and the legislature would have another. You would think over a period of time, by now, that they'd stop, but they haven't. Our legislature in Alabama still have passed several laws since the case dealing with Shelby County, which unfortunately was taking place. So all I'm saying is that all of these cases are very important cases, and you and this law school, I'm very thankful, played a major role in it, because whatever I learned about the practice of law, I learned it here. Not in this building, because it wasn't built then, but the old building that was on the upper end of Adelbert, up near the med school. And I used to live right across the street over here, about 1400 block of Bellflower. It used to be Bellflower House. And had to walk from there up to the law school, which was a nice little walk. But it has been a pleasure to do it. What I do want to say to you, and this is what I have been saying to everybody, it is so important. And I think this election that we're having now points up that fact, that the civil rights history that we have been able to develop didn't start out with a movement, but it ended up being a movement. We didn't start out thinking we would be instrumental in electing an African American to serve as President of the United States. But when you look at what we did when we started with Montgomery and look at all of these movements since then, the sit-ins, the Freedom Rides, the Voting Rights Act, the Public Accommodation Act, all of these things came as a result of people seeing that when you work together on a problem, you can solve it. And one of some of our lecturers today have talked about the lawyer's role. I have always learned, and people tell me quite often, they say, well, you know, you said you did so much in the civil rights movement. I don't see you in any of the movements, any of the marches. I said, no, I wasn't supposed to march. My responsibility was to advise the people who want to march and to arrange it so they could exercise that constitutional right. What many people don't realize that the civil rights movement was a multifaceted movement. And it didn't start on December 1st. You had all these legal cases that have been going on for years. Basically, ever since the beginning. From Sarah Roberts' case up in Boston, that the first case involving segregation of schools. But what we were able to do in Montgomery, and several of our lecturers talked about it, we were able to put together a combination of things. You had to have the legal aspect of it, because in the final analysis, and you know, for the most people, most time, and another reason I'm really, very appreciative for what you're doing here, they have basically written the lawyers out of the movement. You read about the marches, you read about the speeches, you read about the bombings, but what stopped George Wallace and what stopped these other people in these other states are those court orders. And what Judge Johnson realized, and we encouraged him to do it early on, was that if he entered an order and it wasn't enforced, George Wallace would have run him out of the state. So he ended up being one of the first judges who in these cases added the United States of America as a party plaintiff and put them in it, because now I not only have represented this individual plaintiff, but now the United States government is in this case with us. So it's a combination of things. And Joanne Robinson and I, when we sat in her living room on the evening of December the 1st and December the 2nd, when Ms. Parks was arrested, and after she had retained me to represent her, and I said, don't worry about your case, but we want to do something that This won't happen. Won't have to do this every time. Left there and went to E.D. Nixon's house and talked to him. And I said, I'm going and talk to Joanne Robinson. She's had some problems. And we sat there and made the plan. So when somebody tells you that in the civil rights movement, these things just happen, they didn't just happen. There were plans. We anticipated the fact that we needed E.D. Nixon's people, and we also needed Rufus Lewis people, and we also needed Martin Luther King's ability to move people, and they also needed a Fred Gray to do the legal work. And you had a series of things that came over a period of about 15 months that brought together events and persons in one place in Montgomery, Alabama, that resulted in the starting of the civil rights movement. And the rest of it basically is history. What I have tried to do is to kind of summarize a little bit some of the things that you've heard about and you've talked about. But it is so important, as I said earlier, that this history be preserved. And I have been devoting the last 15 years making speeches and trying to get people to contribute toward the development of the Multicultural Center. We have some brochures here, and if you're interested, we'd be happy for you to have it. Because if you understand what has taken place, and you have a whole generation of people now who don't know what has taken place. We want you to come to Tuskegee. We want you to come and to help us maintain what is now developed into one of the best small museums in the country. I want to close, I think, by mentioning one or two other things. And I mentioned this in my little talk to the alumni today. And that is, I really appreciate what you're doing here in Cleveland. But I also realize that even the Lord recognized that people are usually not honored in their own home. But Tuskegee, Alabama, and the Alabama Department of Tourism, and the Tuskegee Human and Civil Rights Multicultural Center is going to unveil a historic marker in honor of Fred Gray on October the 19th at 9:30 a.m. And as I was leaving home yesterday morning, I got a copy of the Tuskegee News, and this is the front page of it. And it says that historic marker to honor Fred Gray. So I appreciate what you're doing here, but I also appreciate what people are doing back at home, and we want you to be a part of it. And again, I want to thank Jonathan, and you know, he handed me an envelope too when he saw me last night when we had a little luncheon, and it was a check for the center. And you may do the same thing if you like. Tuskegee History Center is fine, and we do have some brochures here for you. In conclusion, again, thank all of you for everything. As I had said earlier, I have devoted the last 62 years of my life trying to help to break down barriers. And I've gotten a lot of help along the way. But the award that you give me today and the honor you have bestowed upon me today, you really honor those clients who gave a young lawyer an opportunity to represent them, beginning with Claudette Carbon. Those 623 African Americans in the Tuskegee syphilis study, farmers, most of them uneducated, who said that they wanted to have a permanent memorial in Tuskegee, and all of them are dead now, but I promised them that if life lasts, we would have it. Life has lasted, and we do have it. And on behalf of persons like Miss Smith in Barber County, Alabama, who most of you never heard about before, and all of those unsung heroes and people who you never read about in media, you never see on television, but they are the persons who made it possible so that you could honor me today, and I accept this honor on their behalf. I pledge to you that I will continue to fight for equal justice under the law until all of God's children are truly free. With deep humility, thank you for honoring me, not only me, but for my clients and other heroes whose names never appear in print media, whose faces never appear in television. They are the persons that laid the foundation so that you can honor me. Again, I express my sincere gratitude and appreciation, and have a wonderful life. Thank you.
Let's eat. Thank you. This has been an amazing day. Thank you, Fred. Thank you, everyone. As I said, we'll have a reception out in the rotunda, book signing, and thank you all for being here.